Yep. Okay. Go!
Will you hand me my screen box?
Now go. Preach. Good afternoon. The 14B District Court is now in session for the afternoon civil docket. I apologize for my tardiness today. The court will call the case of Clean Cars Finance Company versus Kamisha Bowden, case number 24C3535.
Good afternoon, Your Honor. Brent Cradwell appearing on behalf of Plaintiff Clean Cars Finance Company.
Good afternoon.
Are you talking to me? Can you hear me? Oh, I'm sorry. My phone. Okay. Sorry about that.
Can you please state your name, please?
Kamisha Bowden, you sound very low. I'm not sure why. It sounds extremely low.
I'm not sure why either. I'll try to speak up.
Kamisha Bowden.
Thank you. All right, Counselor, have the two of you had an opportunity to speak, or where are we with this matter, please?
We had a previous pretrial, Your Honor. And then we had a couple of adjourned dates, and Miss Bowden was going through some things with some personal like people in her family had passed away, it sounded like. So we had a few adjournments. I haven't really spoken with her about the case since our last pretrial.
Do the two of you want to talk?
I'd be happy to speak with her and see if there's a resolution, and if not, then we can
Ms.
come back.
Bowden, you're here for pre-trial today. I see you raised your hand. What would you like to say, ma'am?
Yes, to be honest, I mean, speaking with him would be okay, but I feel like we're not going to come to an agreement with it because it's an unfair amount. Like me owing the whole entire thing is like unfair. So I don't know if I should just kind of like speak to you and then like we figure out a different way, or you decide, because it's not really getting to we're not really getting to an agreement. When I speak with him, I'm not really being listened to about like like the whole situation. So I'm not.
So this is a issue regarding a lease or a motor vehicle lease.
That's correct, Your Honor.
Apparently the car was repossessed and then it was sold for either repossessed or turned in, and it was sold for at an auction, and then this is over the deficiency in that amount. Is that
That is
correct?
correct. Correct.
All right. So, ma'am, I'm not sure where the disagreement is, but typically what happens if you can't reach an agreement on it, what they do is they file a motion for summary disposition where they outline all of the issues and what the amounts are, which will probably be just a repeat of what they have placed as part of the exhibits in this particular case, showing. So it shows, according to them, and they'll just put this in a motion as to why they should win, that there was an original balance at the time of repossession of $8,056,
No.
and then $1,500. What does ACV, a vehicle at time of arrest, what does that mean?
So because it's a lease, Your Honor, it's kind of a weird gray area, different from if it were just a typical purchase. It's like a Mannheim auto auction value. That's how they phrase it on this document, because that's what's been agreed to, with the lease. But also they do wholesale the vehicle at that amount. Like that's the wholesale amount of the vehicle as well.
So they sold the vehicle for $1,500?
That is correct, Your Honor.
What year was it when it was sold? And what year was it sold?
It would have been, so I mean, the date on that letter,
It's a 2010 Malibu.
it was sold in June of 2020.
I'm not sure when I'm able to speak, but if I am, please let me.
One moment, please. 2010 Malibu with a original periodic payments of $220. And this was entered into in 2018. Okay. Ma'am, what would you like to say? We're not having a whole case today. I'm just trying to get a feel for what's going on with the case. Just so
Yeah.
you know.
Absolutely. I just want to say that in the time of them taking the vehicle, I think I owed a little less or a little more than 1,000 on it due to me being pregnant and COVID. I had my youngest son when COVID started. I had got a job when COVID started after my maternity, and I couldn't start that job. I kept in touch with them once every once a week to 2 weeks. I kept in touch with them. I called them. I let them know they agreed to not take the car because of me being pregnant and my maternity and COVID had started. When I was supposed to start my job, they turned around and told me I couldn't because I was doing home health care and that required people to not be in and out of the homes to protect the older people from catching COVID. So I had called them. I let them know, hey, I can't start my new job, but I just filed for unemployment. And as soon as this is the day that it comes, this is the day that I can pay you guys what I owe. And they agreed to me paying what I owed. And they came and took my car 2 days after that, after they had agreed to let me pay that when my unemployment had hit. Because I literally had my son maternity and everything as soon as COVID started.
No,
But I
well,
was in contact with them. I spoke to like two different women back to back. Emails, I had over 30,000 emails that I recently deleted like 2 years ago. I don't have any proof of the emails, but I kept in contact with them back to back and back to back. Like anytime anything changed, I kept in contact with them.
well, it sounds like you aren't going to be able to reach an agreement. Like I was explaining before, I got sidetracked with the nature of the contract here. They'll file a motion for summary disposition. They'll outline all the issues. If they won that motion now, then the case is over and they can get a judgment against you and they start to collect on the judgment. It sounds like the argument is not over whether or not the monies are owed, it's over the amount that is owed. You might want to try to continue to talk to them, see if you can set up some payment plans, see if they're willing to do a dismissal if you have a payment plan as opposed to not a judgment. I can't give you any legal advice, but I'm just telling you their next action would be to file a motion for summary disposition typically. What are you requesting today, Mr. I'm gonna call you counselor because I'm having a hard
That's
time
okay.
with your name,
It's
but
Cradaville. Yeah, no, I
Cradaville.
appreciate it. Yeah, and yes, Your Honor, we would probably plan on filing a motion for summary. So I don't know, as long as the court schedules out any dates with time for me to do that within a week or two, and then obviously Miss Bowden needs, notice so that
time
she
to
can respond.
respond.
And then just to the court's point and Miss Bowden's point, she mentioned being behind like $1,000, and I don't dispute that. I think there's some confusion between what that $8,000, as Your Honor mentioned, represents. It's the full balance of the remaining contract, not what is past due.
But
What,
y'all
what
sold
was
the car for 1,500. Now I have to pay 8,000 after they made agreements with me not to take the car.
Sure. I'm not asking you to like agree with it. I guess I'm just explaining that being behind $1,000 is not the same as the $8,000 number that's on that document. So that's all. I think, I thought maybe there was some confusion there. So I'm happy to speak with Miss Bowden, and or if we can get a trial date and I can prep, I can plan to prep a motion.
I don't do trial dates until we've gotten past the motion for summary
Okay,
disposition point. If you lose at the MSD, then I give you a trial date.
that makes sense.
Okay. So the motion for summary disposition would be scheduled for May 29th. Is that an okay date with your calendar, Ms. Bowden?
And what would this court date? What would this be about? I'm sorry.
Just explain that it's the motion for summary disposition where
So
they're
then
going,
I would have to basically it'll just be telling
I'm sorry.
and it'll be telling me what I'll be paying.
A motion for summary disposition, like I said before, is a motion that they file saying that you don't have a defense to this case and that they should win the case. That is when arguments are made about whether or not you should win the case, or they should win the case, rather. And if they survive that, if you survive that, meaning if they don't win their motion for summary disposition, you would go to trial. But typically, if they file a motion for summary disposition, and you don't respond, first of all, you have to file a written response. They would win that case. And if you can't produce any documentation to support whatever your arguments are, they generally win that case. But I can't give you legal advice, ma'am. You should seek out the legal advice of an attorney.
Okay.
You can call over to the Washtenaw County Bar Association, and they'll do a consult with you. I believe that the fee for a consult is still only $30.
Yeah, I would like that that information.
And you should tell them you're calling about a card deficiency case that was a lease, so they can get you to the right person.
Okay.
Okay?
And Your Honor, you mentioned May 29th is the date.
Yeah.
Did you say a time and I missed it?
I did not yet.
Oh, okay.
I'll do it 2:15. What will call the matter of Merchants Credit Recourse versus Antoinette Salisbury and third-party garnishee Coney Belleville Coney LLC 09C4611.
Good afternoon, Your Honor. Now, Jack Francis on behalf of Plaintiff's Attorney of Record.
Thank you.
Tamir Shami, on behalf of Belleville County.
Well, we already talked before. You can't represent Belleville Coney Island. We had that conversation. Have the parties had a chance to talk, or we already did this garnishment?
No, Your Honor. We were supposed to get a calculation of what should have been withheld from the defendant's checks, and we have never received that, Your Honor.
All right. We were back here on March 13th, at which time I indicated you were to provide the last day of work, any other garnishments, and to provide pay stubs from July 9th, 2024 to the day of discharge, or you would be held in contempt of court. I set it for a show cause. It
Correct,
sounds
ma'am.
like it hasn't happened.
I have it, but I didn't know that I have to send it to them.
You absolutely did, because you were here and I told you to.
Well, it looks like I missed the information, ma'am.
Well, it looks
I
like
did
you're
not.
found in contempt of court.
Well, ma'am, this is not my intention. I'm sorry. But if you wanna tell me that this is what I did, I'm not gonna say anything, ma'am. But I did not mean to do that.
All right, Ms. Francis, what are you requesting today?
Judge, we were requesting a default judgment to enter against the company, the garnishee defendant.
And what is the amount you're requesting?
We were asking for a judgment in the amount of $3,700.71 plus the $100 statutory attorney fees allowed for a total of $3,800.71.
Anything you want to say before I make my ruling, sir?
I told you, ma'am, I have all the information with me and I have it on my email. I can send it to you right now. I can send it to her right now. I did not know that I have to send it to anybody. I supposed to have it, and I had it the second day we had our court date on March. I don't know if you're gonna believe me or you're not gonna believe me. You're gonna do whatever you wanna do, Your Honor. But I wanna tell you at this minute, I retain an attorney for a bankruptcy for myself and my company, and I have a statement for my balance in the bank that it's negative $170,000. I don't know. I don't know. I don't have a video anymore. I don't know why. Okay, now I have it. So this is what I'm saying, and I'm being honest with you, ma'am. I thought that I should have it at the time of the court date. I'm not saying I did. I heard you that I should have it. I did not know that I have to send it to any party, ma'am. I don't know if you're gonna believe me, and I'm honest. I'm telling the truth, and I can go under oath that I'm telling the truth.
Sir, do you have anything else you want to say?
No, I don't have anything else.
All right, we were here on March 13th, 2025, at which time both You were present, and I told you at that time, first of all, that you did not have a right to represent yourself. You represented to me that you were going to obtain counsel for the next hearing. I wrote that down, and also I advised you at that time and ordered you to provide the last day of work, any other garnishments, and to provide a copy of pay stubs from July 9th, 2024 through the date of discharge to the attorney who was present at that time. Nothing has been provided to
I
anybody.
have it on my hand, ma'am.
Don't talk over me again. If you talk over me again, I'm going to hold you in contempt, and then I will give you jail time. Do you understand?
I do.
So I had to have the same conversation with you when you were here last time.
Can I talk? Yeah.
No.
You're asking me?
No,
Yeah.
I'm not.
Oh,
I
okay.
didn't ask you anything.
Okay. Okay.
And we're back here again. When I advised you when you were here last time, you were here because you hadn't provided any of those documents, and you still have not provided them to anybody. In this particular case, I find that the defendant is in contempt of court. Amount that is being requested for a show cause today in the amount of $3,871 will be issued as a judgment, which apparently is not going to matter anyway because there's going to be a bankruptcy filed. We're all done here. Have a
Thank you,
good
Judge.
day.
Did a judgment get provided, or do we need to
It was
submit one?
provided, let me see. No, there's no judgment.
Okay.
You'll need to submit that for signature.
Thank you, Your Honor.
All right, thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What? What is going on today? This is a joke. The gate is an absolute joke. He's an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. You're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
No, trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.